everybody, and welcome back to the Legal Weekly Wine, where we take on the hottest legal topics of the week. And boy, do we have some this week. This week, former President Donald Trump was officially arrested on the Georgia indictments. We have his mugshot. We have issues of bail and bond, speedy trial going on, trying multiple defendants at once, which we will hit in this episode. But the biggest legal question that is circulating through the United States, and we are going to discuss at the very beginning, is whether Article 14, Amendment 14, goodness, I'm getting ahead of myself right here. I'm so excited I can't even say it right. Whether Section 3 of the 14th Amendment actually prohibits and prevents Donald Trump from holding the office of president. This is what's on everybody's mind after a law review is being published by preeminent constitutional scholars, and we have one of our own today. We have Dr. John Weil from Middle Tennessee State University, who is one of those preeminent Constitution scholars who knows the Constitution and has written on it inside and out, who's going to give us his take as to whether there is actually any merit in this article and in this claim. Multiple experts are weighing in, and we'd like to too. So that's where we're going to start today. Then we're going to pick up with those extra legal questions surrounding the arrest of Donald Trump and what that means. I'm Virginia Tehrani. I'm with Tehrani Law, LLC, because you never need a lawyer till you do. And we are being brought to you by The Law Unscripted, which is hosting the podcasts. And here we go with the weekly wine. Welcome, Dr. Weil.
Good to be here.
Oh, I'm so excited for you to be here. Of all of the work that you have done in interpreting the Constitution, your books, I think it's worth mentioning a few, and please add on some that you think, because there are a plethora of them. I know you've had multiple editions of the Rewriting the United States Constitution. You've done multiple books and encyclopedias regarding the First Amendment, the Fourth Amendment. Let's name some others for me real quick.
Well, the companion to the U.S. Constitution and its amendments is probably that. And then I have a essential Supreme Court decision book, which comes out every several years, sort of updates what the Supreme Court has done.
Good. Yes, thank you. So we'll put those in here. You're going to see them on the screen. If you're watching, if you are not watching, if you're listening to the audio podcast, we will put a description and a link where you can access some of those books and see what Dr. Weil has written. But I know you've been a guest with us and honestly, constant companion with us for quite a long time now, and especially now that we've gotten into season 3. But I am truly honored and excited that you were here to weigh in. Because it's the weekly wine, I'm going to do normally I focus a little bit more on the wine. I'm going to do a quick pitch for the wine, and then we're going to get right to it. Today, I am doing an Aloha edition of Grapes and Vibes, and it is Flying Bubbles Rosé. A beautiful bottle, beautiful wine. I've had it before, and it was actually a gift to us from a good friend of mine here in Gaithersburg and Germantown, Maryland, from Dr. Roberto DeSena of Maryland Spine and Health Chiropractic Clinic. I swear I'm going to pronounce my words a little bit better today, but it was a gift from him, especially in the opening of his Germantown office. So thank you, and toast to you, Dr. Roberto, and to your clients and all you do to help the clients of Tehrani Law. And here's to us on August 28th, 2023. Cheers. All right, Dr. Weil, let's get down to it. As I understand it, there is an article, a law review article, and it was written by professors, law professors, William Baude and Michael Stokes Paulsen. And I understand that you've read the entire 100 and something pages.
I have. It was posted online a week or two ago. It's one of these things, and it's paginated and everything, so it looks like it's ready to go. But if it's like my experience with publications is they tell you got to get something in by Monday, and then they hold it for 3 months and publish it thereafter. But it's in a respectable law journal. It's by two very respectable attorneys. And I should mention others are getting on the band.
Attorneys.
Pardon? I'm sorry, law professors. I believe they may practice as well. But what's interesting is others have sort of jumped on the bandwagon. Judge Ludick, who is a retired but very well respected judge, conservative judge, and has paired up with none other than Lawrence Tribe, who is generally considered to be a liberal law professor from Harvard, and basically have said that they agree with the article, which is incredible. To me, none of them are particular friends of Trump, so there's always. But I mean, particularly, you have at least three of them are known as conservatives. And so it's not as though, that they're not partisan. They may not be for Trump, but, presumably they are, the thing to always be careful for is if you tailor an argument for a specific case, then you always need to think, what if it's what if it is a Democrat, the other side being indicted? Or, what if it's me? Right. But they seem to have the fact that this is a law review article versus an op-ed in a newspaper. It seems, and from law professors who, like you, are used to research, detailed research and writing, years of writing and publication, this seems to be a very well thought out and researched article where they've given quite a lot of thought to what the Constitution and its amendments actually say and mean. Right. And it's a fascinating exercise in constitutional interpretation, because for listeners who may not know what this argument is about, it deals specifically with the 14th Amendment, Section 3. So 14th Amendment was one of three amendments that was adopted shortly after the Civil War. So almost everybody knows about the 13th Amendment, which was adopted in 1865, prohibited involuntary servitude, except, by the way, how does it read? Except as punishment for a crime whereof the party shall have been duly convicted. And that actually, there's been some discussion of that lately. That sort of gives a sanction to chain gangs, that sort of thing. And some people will say, well, you should have just eliminated it completely. But what it was designed to eliminate was chattel slavery, hereditary, you're enslaved simply because of your color and because of your mother or your father was also a slave. So 13th Amendment eliminated slavery. 14th, the Dred Scott decision in 1858 had declared, was it 1858? 1857, I believe it was, had declared that African Americans could not be citizens of the U.S. Constitution. And so the 14th Amendment said, and this is also controversial because of immigration issues of late, but all persons born or naturalized in the United States are citizens thereof. And then it went on to, and this is a part that everybody knows, Section 1 defines citizenship. All citizens are entitled to privileges and immunities of U.S. citizens. All are entitled to equal protection of the law. All are guaranteed due process of law. But then there are additional sections of the law. The most commonly cited is Section 5, which gives Congress power to enforce the amendment. But Section 4 also deals with the validity of debt. We're going to pay for the debt of the Union, but we're not going to pay for the debt for the Confederate States. But Section 3 clearly has a historical context. And the context was, you have people, including many senators and generals and others, who had taken an oath to uphold the United States Constitution and then had made war against the United States by joining the Confederate States. And so what the amendment says no person and I probably just do let's see how much we do. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, and here's where we would get to a possible application to Trump, having previously taken an oath as a member of Congress or an officer of the United States or a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid and comfort to the enemies thereof. And then there's a final sentence that says, this, however, is something that Congress could remove. And in fact, after the Civil War, there were some amnesties given to people who, had pledged to the United States, went to the Confederate States, and then said, we're willing to, we lost the war. We understand that. We are willing now to pledge that, we will never again fight against the United States. But the question, now there's a very technical question, and I actually have an a friend who's a professor of law in Ireland who makes a very narrow argument that the president is not an officer of the United States. I think he's wrong. It's a very technical, you have to look at how the word officer is used throughout the Constitution and whatever.
It doesn't actually say the words that you just read from the amendment seem to actually say president and vice president. No,
it doesn't mention it. Let's see.
I thought you just read it.
Or as an executive or judicial officer of any. No,
yeah,
I say yes. Okay, no person should elect or a president and vice president or hold any office, civil or military, under the United States or as an officer of the United States. There's some question as to whether the president is an officer of the United States.
But wasn't he an elector? What does it matter if he was an elector of president or vice president?
No, that an elector of president and vice president would be like somebody in the Electoral College, I think. No?
But he went through that to become the president, didn't he?
No, he's not an elector.
So you're saying the way you're interpreting that is that it has to be an elector from one of the states.
No. I think I've gotten us off base here.
Yeah, no. But
this is why I want to put the whole thing on the screen. When people can look at it, that they can probably do it better than I can do it here. But it's basically, if you're an officer of the United States and you have taken an oath and engage in an insurrection or rebellion, then you're ineligible.
Mm-hmm.
So assuming that what I'm letting people know is that there is a highly technical argument that the president is not an officer of the United States, as that term is used elsewhere in the Constitution. But the issue is, could you in fact say that the president engaged in an insurrection or rebellion against the United States?
Mm-hmm.
And to the extent that one believes Trump is ultimately responsible for the events of January 6th, they certainly have been described by many people as an insurrection. And they seem designed to overturn the will of the American people as it had been expressed through voting and through the Electoral College. Now, the problem it's a great argument.
Yes.
So if we look at constitutional interpretation, the most obvious argument is this was historically based, and that's it. In other words, this
applied to the Civil War.
Yeah, we know why it was adopted. The same reason, and by the way, so I can fill it out, I've done the 1865 13th, 1868 is 14th Amendment, 1870 is a provision that you can't deny people voting on the basis of race. So This is one of three amendments during that time, during what's known as Reconstruction, which lasted until 1877.
And
So,
they're colloquially known as the Civil War amendments.
yeah. And so one way, if you, this is tricky because a lot of times the people who argue for original intent are the same people who argue for plain words. And one could argue, well, I don't know what the original intent was. The most immediate original intent would have been, we don't want people who just fought the Civil War doing what was happening, is they were being reelected in the southern states, and they were effectively continuing their defiance. Now, if you had asked, what if you had said, well, did this apply to future insurrections? They probably said, well, maybe they hadn't thought about it, but probably most of them would have said yes. But more importantly, the language doesn't say this only applies to people engaged in the Civil War. It says any of these who engaged in insurrection or rebellion. So the language itself would suggest that. Now, what's interesting about this, and one of the things that Paulsen and his colleague had to answer was, is this illegal because it is either an ex post facto law or a bill of attainder?
Okay, describe that for us.
Okay, so an ex post facto law is a law that makes something a crime that wasn't a crime when it was committed and punishes you for it. Yesterday you read Sense and Sensibility, violate the First Amendment, but yesterday you read Sense and Sensibility. Anybody who read Sense and Sensibility yesterday shall be sentenced to jail. That would be an ex post facto law. Okay. Or making a punishment greater than it was when it was committed. A bill of attainder is similar, although it usually involves naming individuals. It's basically a legislative punishment that is imposed without the benefit of a trial. All supporters of Trump or all supporters of King Charles are hereby committed to the London Tower, the Tower of London, or whatever. So they are prohibited by Article 1, Section 9, and I believe it's also prohibited to the states in Article 1, Section 10. But Congress is prohibited from adopting either of those. But the authors of the article argue that doesn't matter because the 14th Amendment comes later, and it is a modification of the usual rules of ex post facto, bill of attainder, or any other provisions in the Constitution. So there are some of the interpretive issues. Now, there's another interpretive issue, which is, if you look at Article 1, Section 2, what did that tell you? Was it Clause
Article
3?
2, Section 1, I think.
Yeah, Section 1.
2, Section 1, Clause 5. Before we go to that, let me say real quick, in talking about the bills of attainder, of the ex post facto, of what Congress's intent was, to me, as, yes, I'm a lawyer, but in looking at it more as what I feel is a regular person is saying, well, but if it's a full amendment to the Constitution, it's not just a law passed in Congress. I mean, there are many laws passed in Congress, but how many others do we remember from the 1800s? Right. It takes a lot to become a part of the U.S. Constitution.
Yes, it does.
And the fact that many people could actually get together and agree to an amendment of the Constitution, to me, it seems clear that they really intended for it to be there. They intended for it to be there not just for a specific period of time, but in my mind, the argument is they really intended for it to be there in perpetuity, so that it would be, people after them could see, oh, this would be a consequence of what would happen to me if I engage in insurrection and or rebellion and or supporting and aiding comfort, providing comfort to those who do, let this be a warning that we are so committed to the Union and to our Constitution that we don't want anyone who goes against the Constitution to be part of a government that would then undermine it. So to me, in looking at it, it seems pretty clear.
It does. Now, there's another little wrinkle, which is Article 2, section, clause, what'd you say? Section?
Yeah, Article 2. So we're on to Article 2, Section 1, Clause 5, which I have not heard talked about in the news.
Well,
how does that apply?
Okay, so it sets forth the qualifications to run for president.
Okay.
So no person except a natural born citizen or citizen at the time of the adoption of the Constitution. I qualify on both scores, by the way. No, okay. Shall be eligible for the office of the president, who has not attained the age of 35, been 14 years a citizen resident within the United States. So this is not listed under those qualifications.
Right.
And there is a well-known case, not McCulloch versus Maryland, Powell versus McCormick, in which, dealing with a similar issue, which is the qualifications of a member of Congress, the court says these qualifications are exclusive qualifications. Now, they weren't thinking at the time, but this is somebody who's also engaged in rebellion against the United States.
Right.
But they're fairly emphatic that what happened is Congress tried to expel someone without requiring a 2/3 vote. And they said the Constitution says, no, you're elected to office. You can't second guess a person's election once you've seated them. You can expel them by a 2/3 vote, but you can't exclude them. So again, I think the argument would probably be, and it's been a week or so since I've read this article that Paulsen and his colleague originally published, but I think the argument would be similar to the argument for a bill of attainder and ex post facto, that it comes later, so it's a necessary addition. Now, where the rubber hits the road, and here's where I am concerned about the argument, I don't know how it's enforced.
Yeah.
Well, and it's not so much that I don't know how it would be enforced as I don't know how it would be enforced uniformly. So typically states determine who gets on the ballot. And the court has had some decisions which basically say, you can't be arbitrary about this. If you say 10,000 10,000 signatures are needed, you can't require 20,000 of a Democrat or 30,000 of a socialist or whatever.
Right.
But who is going to step forward in each state and say, and what would happen if Trump were to appear on the ballot of half the states and not on the other half? Right. Because let's say, Democratic attorney generals would work to keep him off and Republican attorney generals would work to keep him on.
Yes.
So I think the answer is, if there's time, it would go to the U.S. Supreme Court. And there's been a lot of criticism of the court in 2000 and some praise. The court settled the matter. They stopped the count. The vote went to Bush. Bush was declared to be the president. But there was also a lot of people who said the Supreme Court should have stayed out of it, let the political process play itself out, rather than, make it look like they were partisan. So I just don't know what happens. And there may be other people other than secretaries of state who could bring some suits. And I would think almost surely on an issue like this, you would have divided courts. And would the Supreme Court be able to act quickly enough to say either he's not on any ballots or he's on all the ballots. And then the other fascinating issue here, and there's another constitutional clause that comes into play. This also mentions, any person or a member of as a member of Congress has taken an oath. So what about the people on January 6th who stood up in Congress and said, we're unwilling to certify the votes in Arizona and Georgia and whatever? Did they engage in insurrection as well? Now, one of the problems would be, so to go to the other clause, you can't be arrested, you can't be punished for anything that you say on the House floor. Now, and then part of the issue in the original, in this real long article, is this a punishment? Is exclusion a punishment? It's not a punishment to say you can't be president until you're 35, or we don't consider that to be a punishment, but this is a little different. So it really opens up. I mean, of course this is written by lawyers. People are going to make some money on this. We're going to have suits all over the country.
Right. So the biggest issues to me in taking that is I saw an interview, an article of an interview with Ludwig, former Judge Ludwig.
Yes.
Where he was saying that it's categorical, that there's no room for interpretation. It is or it isn't, and you can't or you can.
Right.
But what he was saying is he believes it's up to the individual. Let me make sure I'm getting this right. It's up to the individual states of the people who look at who can qualify and be on the ballots.
Right.
That whoever is in charge of reviewing the qualifications for who gets on the ballots and who doesn't, that they are the ones who have to decide whether he's violated the Constitution.
But does he think they're all going to vote the same way? I mean,
he believes that, of course, they should.
Right.
To him, he's saying it's very clear Donald Trump engaged in insurrection.
But that's a better legal argument than it is a political argument to expect.
Right.
Yeah.
Right. So he's saying, look, everybody's tasked to uphold the Constitution.
Right. Absolutely.
Anyone in the state who is certifying or including someone on the ballot or certifying that they have won the ballot. And he's saying it's up to those people to decide because they're charged with upholding the Constitution too and following the rules of the Constitution. And he's saying they have to not put him on there. His argument is at the very bottom level, they shouldn't be put on there. And if that is the case, and we start seeing, like you're suggesting, that it goes up through the states, if we start seeing individuals from the states or individual states refusing his name on the ballot or taking his name off of the ballot, saying constitutionally under this section, we're not allowed to, then I think those suits would start very quickly. That the base for Trump, the Trump voters, so to speak, those who put him in that spot,
they would say they're being denied their right to vote.
Absolutely. We're voting for who we want. This is the will of the people. The Constitution lets us vote for who we want. This is who I'm voting for. You're not putting him on there. And I think it would go up very quickly. It would have to, because we're almost at the election next year. And I think it would almost be expedited because the issue is so big. The Republican nomination
is. But would you want to be on the court to have to decide that?
Well, no, but you have to, whether you want to be on the court or not, you're a judge. And if it comes before you, that's your job.
Right.
Certainly.
But do you think it would be interpreted, whatever they did, would it be interpreted as a legal decision or as a political decision?
It would have to be a legal decision. And in my mind, this is a legal argument, is an interpretation of the Constitution. It's not political. It's not, is it a Republican or a Democrat? It's not, are you conservative or liberal? It's, are you actually violating a clause of the Constitution? And what place is the court for but to say this is how we interpret the laws and the Constitution? So I
The
believe
problem,
that
of course, is right. The problem is, of course, is it's very unlikely that Trump's trials, particularly the indictments by the U.S. Attorney General, the special counsel, would be resolved by then. So
the arguments that they're making,
right.
at least for Ludwig, and I haven't read the full article like you
right.
have the original article, but at least
the Ludwig tribe article, I think, is in the Atlantic, right?
I think so. The one that I am referring to is, let me make sure I've got this right. And of course, there we go. It is the title. It's in the New Yorker, the constitutional case for barring Trump from the presidency. This was published on August 23rd, and it's an interview with Judge Ludwig.
Okay, well, I think they did a joint article that may have been in the Atlantic. I could be mistaken.
That makes sense. And I know he and Lawrence Tribe, they wrote, yes, the article for the Atlantic. So that's where they put forth their opinions. But what they're saying, or what Ludwig is saying, is it doesn't matter if it's a conviction or not. He's saying it's not based on conviction, it's based on behavior. Right. And if the behavior is an insurrection or rebellion, then we don't need to wait for a ruling on a criminal side. We don't need to wait to whether he's been found guilty or not guilty, but only look to his behavior.
And here's where I think, this is where, if you're on the Supreme Court, the pressure is going to be to make a quick decision.
Yes.
But you've got to put in people could say, well, he said we should get at, he said we should invade Mexico. That's rebellion against the United, or he said we should attack, get out of Ukraine. We have to be careful that we understand that rebellion and insurrection against the United States is not just, as you've already sort of pointed us that direction. It's action. It's not mere speech.
Right. And I think that's where, to me, the legal argument is going to be based. That's what it's going to turn on, is the definition of insurrection and rebellion. To me, that's what the courts are going to have to struggle with. They're going to have to struggle with, well, does his behavior in any way, do his actions related to and leading up to January 6th, his alleged attempt to overturn an invalid election, again, alleged, and there are so many different pieces in it, but I think the judges and even the Supreme Court will have to deal not with, will he be convicted under state or federal laws, but constitutionally, does his behavior fit within the definition of rebellion and insurrection as defined constitutionally under
but I don't think there's a definition in the Constitution, is there?
There's not.
There's a definition of treason. It's one of the, I think it's the only crime that's actually defined in the U.S. Constitution. But the terms insurrection and rebellion, to my knowledge, are not defined.
They are not. And that's why when Judge Ludwig says, well, this is easy, he's either, he shouldn't be put on the ballot. Well, it's not easy because there is no official definition, especially not within the 14th Amendment. You read the clause and there's no definition of insurrection or rebellion. So the question is, how is that interpreted?
Right.
And how do we get to it? And can we get to it before the election?
Right.
And what if we don't? So here's my biggest question is, what if we don't get to it before the election? What if former President Donald Trump is reelected and becomes the president, but then there are lawsuits and
that say he's not qualified,
shouldn't be the president?
Right.
Do we take him out? Do we, once he's there, do we then take him out and put the other person in? To me, it's almost because of that issue.
And of course, what could happen, and this goes to another unresolved question, he could simply pardon himself. Or, he could try to pardon himself, at the federal level. Now,
can't pardon, as we understand and talked about on the last episode, he cannot pardon himself for state, or no one can be pardoned for state offenses except through the states.
That's right. And that's the significance of the mugshot that we saw on Thursday, and the movement down, to trip down to Atlanta.
Right.
And frankly, it's become something of a mockery. I never really thought I was, I understand someone like Martin Luther King Jr., who says, I'm willing to go to jail to violate a law that I think is unjust.
Right.
And, people who are criticizing me, they should be criticized for not violating the law. But it's hard to understand, particularly someone who has sworn to uphold the U.S. Constitution, essentially, using a mugshot to raise money for himself. That seems to me to be a mockery of the criminal justice system.
But in his mind, and of those of the supporters, as on the other side, devil's advocate, is, well, it's the shot that says this is being done to me unjustly. It is the essence of what is being done is I'm being made to be a criminal.
Right.
When as he's saying, the justice system is being used as a weapon against me.
Well, I mean, any person accused of a crime can make that argument.
Absolutely.
And the proof ultimately is in the conviction or not conviction. I mean,
right. And that's what we're waiting on.
Right. He has had as far as I can tell, he has had due process in the indictment process.
Correct.
Attorneys have brought evidence before a grand jury, and the grand jury has said, yes, there's probable cause to proceed to prosecute.
Yes.
He's been treated, I mean, frankly, it's hard to complain. How many people who show up at the Fulton County Jail to be booked are given an escort with six cars and 25 motorcycles and all traffic stops as they go through? Right. It's hard to say he's being picked, now. Yeah,
well, the idea isn't so much that he's being picked on in the actual charging and what happens, with the charges, but the fact that he's being charged at all, that he's being investigated, that the idea is that the system as a whole, whether it's the Georgia ones, especially Jack Smith and the federal cases, that those are being used specifically to get at him and to prevent him from running and to prevent him from being president, that it's not a process of bringing justice in a criminal sense, but bringing a political action against a political rival is the way that he's presenting it.
Right. Well, again, the proof is
in that particular way.
Right. We know hundreds of people have already been convicted for participating in January 6th.
In DC, right.
Right. And it's, if anything, one might argue, he's escaped 2 years or so without any indictments against him. Now, the chickens have arguably come home to roost.
Yeah, and it's one of the other interesting things. I'll do a final note on that, and then we'll move over to bail, speedy trial, and multiple defendants. Within our little hour, we still have a little time. But one of the final comments I had was timing. Mm-hmm. With all of this, there's been a lot of criticism by President Trump and his supporters that it's, look, you're doing this, the timing is poor. You're choosing timing inappropriately to prevent me from running, to interfere with my election, with me proceeding through an election, which, timing is that way because we're getting into the race, we're getting into the season for it. But in looking at the rules, especially in Georgia, and each state and each part of the government has a rule called the statute of limitations.
Right.
And that means they have to bring crimes. They have to charge crimes within so much time, or they completely forever forfeit the right to do so.
Well, not all crimes, but most.
Most crimes,
Murder, yeah.
murder is famous. You know,
Right.
if you commit a murder, there's no state or jurisdiction that I know that doesn't have an infinite, forever and always you can bring a murder charge.
Right.
But for most charges, most misdemeanors across the
Yes.
country, it's a year.
Felony.
You have to bring them within a year. Most felonies have a statute. It depends on the state. For Georgia, it's 4 years. You have 4 years from the time of the behavior to the time that you prosecute. And you have to charge within those 4 years. So in looking at the case, the timing is what, this year or next year, by the end of next year, that she would have to bring it?
Yeah, I mean, she's gotten a lot of criticism for waiting this long. But one of the fascinating things is, and this, I know we're going to get to this. So there's 19 defendants, I believe, including former President Trump.
Correct.
And one of them has said, I want my trial on October 23rd.
Right.
Basically, within a month.
Yes.
And apparently, if he doesn't get it, then according to the laws of Georgia, they can't prosecute him.
Correct.
So, the Sixth Amendment, I'm sure we're going to get to this, but the Sixth Amendment, all criminal prosecutions, the accused shall enjoy the right of a speedy and public trial. Now, the language suggests that the primary beneficiary of a speedy trial is the defendant.
Yes.
And I guess the reason is, I mean, when you have an indictment against you, you sort of have a cloud over your head. And
you're possibly sitting in jail.
Well, that's right. If you don't have money for the bond, you would be sitting in jail. But I think there are some who have also been arguing that a speedy trial might, although it says the accused should enjoy the right, that maybe there's a public dimension of speedy trial as well, that fellow citizens have a right, particularly in a criminal case, to see that prosecution proceeds expeditiously.
And that justice is being done, due process is being followed. Right. Public needs to see that it is.
Right. But what's fascinating, of course, is, and you've been in the courtroom as a litigator, and I have not, but what's fascinating about the Georgia cases is you have the possibility, my understanding is Willis wanted to try all of them together.
Yes.
Intent. Talk about a lawyer's heaven, right? You get 19 different lawyers.
Objection. Okay, let's hear from all 19 of you. Jury
exactly
will tomorrow.
In any event, one of the defendants has said, I want mine next month. Trump, is my understanding, had proposed a date in 2026.
Yes.
He's in no hurry, and probably in part because he believes if he's president, he might be able to pardon. Well, he couldn't pardon himself again. Can't pardon himself for the state charges, but it would be presumably some of his supporters would give a second thought if he had actually been convicted. So, you probably don't want to run as a convicted felon for office. So his, and as the longer trial, the more you postpone it, the greater chance that memories fade, people die.
Yes.
Any number of other things, maybe political winds change, all of this. But what's fascinating about this is if this request goes forward, and apparently, well, let's go back to why did Willis take so long? Well, it may be that she recognized this was a possibility, and you have to be ready to hit the ground running.
Yes.
You can't say, well, no, I don't want you to exercise your right because I'm not through yet. No, you have to be ready to bring. So the fact that she waited close to 2 years to do this might, maybe there are other factors too, but it might. But what's fascinating, and here you can help because, my predilection, if I were rewriting the Constitution here, is that if you had multiple cases like this, the attorneys for other defendants would not be in the room. But apparently they have the right to sit in on this prosecution, and depending on, first you see, was he declared, if he's declared not guilty, right, then some of them will say, well, this is a strategy he used that's pretty effective.
Absolutely.
But if he pleads, if he's convicted, then you can say, well, we know what her strategy is. Let's prepare, how would we answer that argument? So it gives them sort of a preview. And again, he's either this is probably a brilliant maneuver. I know you told me this earlier, that you think it's a brilliant maneuver. The only way it might not be is if there's a chance that he could have plea bargained, well, I'll give you all the scoop I have on Trump if you let me off. If he goes to an early trial and is convicted, my understanding is that he loses that ability. So it's either, depending on the outcome, we'll either say his attorneys are, the most brilliant, or, the dimmest of the lot here.
Well, and so for Georgia, the way that it works in Georgia, and again, each state has different timelines, because in the Constitution, as you read off, there's no specific time for speedy trial. It just said speedy and public trial. It is the defendant's right, but each state defines when that is. Some states it's like 9 months, sometimes it's 12 months, but it's fairly close in time. And the time that it starts running is on arrest or indictment.
Right.
And in Georgia, it's on arrest. So yesterday it started running. August 24th, 2023, Trump's speedy trial started running. Each of the defendants, as they turn themselves in and are arrested officially, their clock starts running.
Right.
And in Georgia, the way that the rule is read for speedy trial is the trial must be within the second term of their arrest. And in this case, the way that this is quick. So like you said, she has to be ready to go. Yep. She has within, the max is 4 months, depending on when the arrest is made. So in Georgia, one term began July 1st and ends August 31st. It's 2 months per term. So Trump is arrested it's correct. He was arrested at the end of August, which is the first term. And according to that rule, the trial would have to be done within the end of the second term, which is the end of October.
Now, this is if they claim the right?
Correct.
If they ask for it, right. If they ask for for a speedy trial.
Demand, yes. The defendant has to, according to the laws and the case law that's surrounding it, there are 4 factors that go into speedy trial. One is whether it's what the length of delay is, why the delay is. So length of delay, reason for delay, prejudice to the defendant, and whether they made a demand. So
am I right in this case, Trump had indicated earlier, Trump's attorneys had already filed that they would need considerable time, because according to them, there's something like 2 million pages of documents, or I don't know if there are that many, but a huge amount for them to have to go through. Presumably the DA has been working on this for 2 years, and they've had it for month or so, whenever the informal indictments were issued.
Right. So Trump has not alleged his right to speedy trial. He has not claimed it. Right. It has to be by individual separate motion saying speedy trial demand.
Right.
He hasn't put it in, but his co-defendant did.
One of his co-defendants
did. Right. And what's happened then is he's saying, yes, I want the ability. So Fani Willis said, okay, we've got October 23rd. That's within that time period, because we only have till the end of October. So here's your date. Now, here's what's fascinating the most about it is he has to go through the same documents, right? His attorneys are given the same documents because it's the same allegations, many of the same charges, the same scheme. And if a judge is looking at Trump's request to do this in 2026, if I were the judge, and this is whether it's Trump or anybody else, I would be looking and saying, wait, now, okay, so you're saying you can't do this for 3 years, but your co-defendant did it within 2 months and had trial. So how are his attorneys better than your attorneys? That's what I would do as a judge, is look at it saying, well, if all of the defendants and their attorneys were saying this is insurmountable, we cannot do it within the prescribed speedy trial, we don't want our speedy trial, we all want a delay, then that would actually improve Trump's chances of getting a delay. Maybe not to 2026, but in this case, his co-defendant has gone in and thrown down the gauntlet by saying, I want the speedy trial. I can be ready in 2 months' time. Bring it on. Here we go.
And part of it, in my understanding, if they were to be done seriatim, so individually, could you use earlier convictions?
Yes.
Or later ones. So he won't have anybody in front of him who has been convicted as a co-conspirator. Whereas if he comes later down the line, and many of them have, he might be in greater legal jeopardy.
That's exactly right. So what happens, especially in a conspiracy environment, whether it's a RICO charge, which is technically a conspiracy, right? You're alleging there's an enterprise, an entire group of people in this case that is conspired and worked together to produce this effect. And with that, you can, just like if you're prosecuting a gang, you can use their convictions for that crime, for that same conspiracy, for that same enterprise, to prove that there was such an enterprise.
Right.
So Cheeseburger goes in and there's no prior convictions. Nobody else has been convicted. You can't even necessarily say that they've all been arrested, depending on, the evidentiary rules. But Fani Willis can use the prosecution to say, well, there are all of these other co-conspirators. There are all of these others involved in the enterprise. But what she can't say against him is they've already been convicted that this was an enterprise. So a court has already determined, a jury has already determined that there is an illegal enterprise and that these people were part of it because they're already convicted. And because these people were a part of it, well, Mr. Cheeseborough picked up the phone and talked with them. He worked with them.
Fani Willis might be in the same position that John Sirica was in back in the Watergate. You won't remember this, obviously.
I remember Watergate, but not that particular part.
Well, in Watergate, what he did, he had defendants before him that he would not, either he wouldn't give them bail at all, or he gave them unusually harsh sentences in the hope that one of them would crack, and one of them eventually did.
Absolutely.
And he was named, if I recall, Man of the Year. It's a federal judge who, prior to that time, actually I think he was called Hanging John or something. He had a reputation as being pretty harsh, but maybe not always in a good way. But in this one actually sort of cracked the case. And here you have, somebody, I mean, it is interesting, isn't it? I mean, you have someone at the state, and I don't know Willis that well, but, someone at the state level who possibly could have a major impact on a national issue. Absolutely. And of course, from her perspective, her job, she believes that someone was trying to keep legitimately elected electors from her state from voting as they had been voted, to casting their vote as they had been asked to do. So she's simply, from her perspective, simply upholding Georgia law.
Mm-hmm. Yeah, I agree with that. So with this issue of these 19 defendants, and again, I have called the legal maneuvering here is so fascinating.
Yes.
We're truly in a historic time. And I feel privileged to be a part of this time, to see the forefront of what is happening. The basic legal maneuvering here with these 19 defendants, you're absolutely right, with Watergate. So what's going to happen here is if they pick off individually, and one has a trial, then another has a trial. If they continue to get convicted, I'm not saying any of them will, but
we don't know.
If even a significant majority do, then the next defendants would be like, oh my gosh, I better do something. Because if there's a really harsh sentence for Cheeseborough, the next person's going to say, wow, well, he's an attorney. He's going to, and this is what they did to them. What chance do I have? I'd rather make a deal than risk a jury. Now, each jury is different. You don't have the same jury. But the more it goes along, the more likely it becomes the prosecution gets easier.
Well, unless it goes the other direction.
Right.
Unless it goes the other direction. Yeah.
But if it goes in the conviction sense, they'll have more practice.
They'll know
what works.
To bring up Watergate, the big difference between this and Watergate is, when Nixon was never indicted.
Right.
Well, he was named as an unindicted co-conspirator, which is a term we've talked about before on here. But he was pardoned by Ford before he was indicted.
Correct.
But what happened is President Nixon resigned. And the reason he resigned was, first, there had been, as there had been with President Trump, there had been congressional investigations. But leading senators, leading Republican senators, came to him and said, Mr. President, we're about to have impeachment charges against you. We think we would have to vote with the impeachment. And he realized at that point, if he didn't have the support of his own party, then he would undoubtedly be impeached and removed from office. Sure. Now, in this case, for reasons, complex reasons, a lot of Trump's supporters continue to support him.
Yes.
Even after, well, of course, they supported him through 2 impeachments. Mm-hmm. The second of which I think certainly was much stronger than the first. But they continue now to support him through indictments. And again, he is legally innocent till proven guilty.
Absolutely.
But, people in the Republican Party have got to worry about what would happen if he is convicted between his nomination and his election.
Right.
And, to go back to our earlier discussion, if I were a Republican opponent of President Trump, I think at the Republican National Nominating Convention, I would be making the argument that we shouldn't nominate someone, even maybe if he had won the primaries. We cannot afford to nominate somebody who has actually been indicted and or maybe even by then convicted. That seems I don't know.
It will be hard. And then when we get it going back to our discussion about what do the courts do and what is the timing, in either sense, there is a risk if he runs, which he is continuing to run. There is a risk for both parties. If he gets elected and then is removed by the courts, what does that do? But then
I think the 25th Amendment covers that. I would have to go.
Yes, but yes.
In other words, I think his vice president, I think would then be whoever the nominee is.
Correct. There is a pecking order of who
happens. Right.
But the larger question is, well, is that what we didn't want that person? It wasn't about the vice president. It was about the president. And now our president is being removed. But the question to me is, yes, the vice president would be there. But the larger question is, if they were improperly done, then shouldn't it go to the Democrat? Shouldn't it go to the other party? And vice versa. If the Democrat became the president and Trump was removed by court order or was not allowed by court order, but should have been there, then can we take the Democrat president out and replace him? So yes, there's a pecking order once the party is actually elected, but then now we're really getting into the election was stolen. The new election, both Republicans and Democrats are already set up in a position to decry the election was stolen from us, because either Mr. Trump could not have run, and if he wins, he should not have been in there, nor should the Republican Party. It should have been Democrat Joe Biden or whoever it is that officially receives the nomination. And in the alternative, the Democrats would say, well, if Mr. Trump is now president again, but shouldn't have been, then it's Joe Biden, or who our nominee was. It's not his vice president. It's not the 25th Amendment that applies. It's the original Constitution. This article, is Section 2 of Amendment 14. And now we're looking at a review and reorganization of power. And in my mind, to me, there is urgency in deciding and figuring out this particular issue that has been raised.
In other words, whether Trump can legally run for president.
Correct, because it's going to be so much harder of a national trauma is one word for it, but another larger issue for the entire country as a whole. So to me, time is of the essence for all of these trials, for this constitutional issue.
And of course, the problem, right, is we're not going to actually get to the issue of Trump on ballots until whenever the convention is.
And when is that?
I knew you were going to ask.
Right?
Usually June-ish.
Of next year.
Yeah.
Yeah. So do we have to wait till then, and do we speed it up, and how do we get it up to
I mean, who else can again, I think at the Republican National Convention, one could raise a challenge.
Sure. At least initial challenges is, could he be the Republican nominee?
Yeah, but that wouldn't necessarily be a legal challenge there. It would just be sort of a prudential, do we want to elect somebody who might in fact be convicted? And, and we've talked, again, if for federal charges, can a president pardon himself? I'm inclined to say no, that it's just so, but it's one of those times where you're sort of making almost a natural law or natural justice. Well, I guess you call it due process. Mm-hmm. I don't know any other, we certainly have cases, can a person fine an individual if that person is getting a cut of the fine? Right. And the answer is no. Right. And you certainly could probably work from cases like that to say, well, no person should be judged in their own case.
Right.
But the other, we're back now to constitutional interpretation. If the Constitution doesn't specifically, it does have a specific limitation, you can't pardon someone who's been impeached for that offense. But if that was a qualification and it's the only one they listed, maybe that's the only one they intended.
Right.
So, could they have, coulda, shoulda, woulda, could they have imagined having hopefully they would have found it hard to imagine a president who had committed a defense that he needed to pardon himself from.
It seems a little outside of the normal realm of thinking.
Yes, it does.
Historic times, whether you agree or disagree with what's happening, I think everyone can agree that these are historic times.
They are.
So here's what we're going to do. We're right about at that hour, which I hate to go over the hour. So we're going to postpone the issue of bail and bond. That would be a fascinating issue.
Yes, it is. Give us the time to do a little more research.
Exactly. So that will be coming up because, these defendants are being placed with, bail bonds and they're getting surety bonds. So we can discuss what that means later, and especially in terms of President Trump. But what we will do is we will wrap up our conversation today. Stay tuned for next week. These are highly important and interesting legal times. Political, yes, but at least for me as the attorney and for Dr. Weil, for the Constitution expert, legal times indeed. So we wish you a wonderful happy hour. We hope you grabbed your own glass of wine or something to enjoy the end of the Friday and end of the week, and that our conversation spurs you on to continuing conversations of your own. Check back in with us for next week. Let's see what happens and what else we can confuse you and ourselves with, and have a lovely conversation. Dr. Weil, thank you so much for joining us again.
You're welcome. And just as advice, do not engage in any rebellion or insurrection against the United States until you hear the next session.
Please don't. And yes, as an attorney especially, I cannot advise you. I am not providing legal advice or instruction, but the one piece of general legal advice I can always provide to anyone is please don't engage in any acts of violence or threats of violence. That is a recipe for disaster, legally and otherwise. But that is where we stand, because I am with Tehrani Law. I am not representing anyone in this case, nor do I have an association with any of the parties in these cases, federally or state-wise. We are simply making legal analysis and discussion regarding the issues that are raised through these indictments, through these cases, and through the constitutional analysis. So with that, happy Friday. Thanks for joining us at the Legal Weekly Wine.